133, Methods of Dissolution. This section outlines the two primary methods of dissolving a corporation, voluntary and involuntary dissolution. Voluntary dissolution happens first if it is initiated by the board of directors, trustees, stockholders, or members. Second, if it is subject to SEC approval if the creditors are affected. Third, through amendment of articles of incorporation. And fourth, if it is in case of merger and consolidation. However, on the other hand, involuntary dissolution occurs due to several factors including expiration of the corporate term, legal enactment, court orders, or if it becomes inoperative for 5 consecutive years. Also, the SEC can dissolve the corporation if it violates an existing law. But more importantly, either of these two methods shall strictly comply with the requirements for dissolution mandated by this code.
Section 134, voluntary dissolution where no creditors are affected. If a voluntary dissolution will not affect any creditors, then the dissolution can be effected by the majority of the directors or trustees and by a resolution adopted by affirmative vote of the stockholders who owns at least the majority of the stocks or at least a majority of the members. A notice shall be given to each stockholder and members 20 days prior to the meeting, and a verified request for dissolution shall be filed with the Commission stating the reason for dissolution and the other information required. The corporation shall submit a copy of resolution authorizing the dissolution to the Commission. They shall also submit a proof of publication and a favorable recommendation from the appropriate regulatory agency when necessary. After complying, the Commission shall approve the request 15 days from the receipt of the verified request for dissolution, and the dissolution will take effect upon the issuance of the Commission of the Certificate of Dissolution.
Section 135, Voluntary Dissolution of a Corporation Affecting Creditors. To voluntarily dissolve a corporation affecting creditors, a verified petition must be filed with the Commission if the creditor's right may be impacted. This petition must be signed by a majority of the board and verified by the President, Secretary, or a board member. The dissolution must be approved by 2/3 of the stockholders with outstanding capital stock or members during a specially called meeting, and the petition must outline the reason for dissolution, notices provided, and meeting specifics. Required submissions include a certified resolution signed by the board majority, countersigned by the secretary, and a list of creditors. The Commission reviews the petition's form and substance, sets a 30 to 60-day objection period, and orders publication of the details in a newspaper and posting in 3 public places for 3 weeks. After the objection period, a hearing is conducted, and if no valid objections are raised and the petition is substantiated, the Commission issues a judgment for dissolution, directs assets disposition, and appointment of receiver for debt payments. The dissolution takes effect only when the Commission issues a certificate of dissolution.
Section 136, Dissolution by Shortening Corporator. A corporation can voluntarily dissolve by amending its articles of incorporation to shorten its corporate term. The amended articles must be submitted to the SEC. Once the shortened term ends, the corporation is automatically dissolved without additional procedures except for handling liquidation according to the law. If the corporate term expires naturally, the dissolution automatically takes effect the day after the terms end, without needing a formal dissolution certificate from the SEC.
Section 137, Withdrawal of Request and Petition for Dissolution. Section 137 outlines the procedures for withdrawing a request or petition for dissolution. A withdrawal request must be in writing, verified, and signed by the same number of individuals required to initiate the dissolution, and it must be submitted within 15 days of the Commission receiving the dissolution request. The Commission will then withhold action and may declare the request withdrawn. Direct a joint meeting of the board and stockholders or members to decide on proceeding with dissolution, or issue other appropriate orders. For withdrawing a petition for dissolution, a verified motion with similar content is required, which must be filed before the publication of the order setting the deadline for objections.
Section 138, Involuntary Dissolution. A corporation may be dissolved by the Commission motu proprio or upon verified complaint of any interested party. There are 5 grounds for a corporation to be dissolved. First, the non-use of corporate charter. Second, continuous in operation of the corporation. Third, upon receipt of lawful court. Third, upon finding by final judgment that the corporation procured its incorporation through fraud. And lastly, upon finding by final judgment that the corporation was created for the purpose of concealing, committing, or aiding the commission of securities tax evasion, violations, money laundering, or grafts or corrupt practices, and the stockholders knew the same, and they repeatedly and knowingly tolerated the commission of grafts or corrupt practices or other fraudulent acts by its directors, trustees, or employees. Any corporation dissolved by final judgment, its assets, upon paying all its liabilities, will be forfeited in favor of any national government.
Section 139, Corporation Liquidation. Section 139 states that a corporation will continue to exist for 3 years after its dissolution to wind up its affairs. This includes disposing of its properties and distributing its assets. During this time, the corporation can resolve lawsuits and settle affairs, paying off debts, collecting receivables, and fulfilling contracts. As an addition, the corporation cannot continue its original operations during this period. And when the corporation's affairs are wound up, any assets that cannot be distributed to known or unknown creditors, stockholders, or members will go to the national government. But take note that a corporation cannot distribute its assets or property unless it is lawfully dissolved and has paid all its debts and liabilities. However, an exception to this provision are the banks, because banks have a different process for dissolution as outlined in the new Central Bank Act and the Philippine Deposit Insurance Corporation Charter.
Section 140, Definition of Rights of Foreign Corporation. A foreign corporation is any entity formed under the laws of a country other than the Philippines. To operate in the Philippines, its home country must allow Filipino businesses similar rights under the principle of reciprocity. Foreign corporation can only conduct business in the Philippines after fulfilling 2 key requirements. First is obtaining a license as required by the law, and second, securing a certificate of authority from the relevant government agency. These requirements ensure compliance with the Philippine legal and operational standards. The framework emphasizes reciprocity, allowing foreign businesses rights only if their home countries extend the same to Filipinos. It also ensures regulations and oversight, requiring foreign corporations to adhere to Philippine laws. By doing so, it enables market access for foreign corporations while protecting national interests and maintaining fairness in international business relations.
Section 141 is all about the application of license of an existing foreign corporation, and it means that an existing foreign corporation who has a license even before the effectivity date of the revised Corporation Code of the Philippines is not required to acquire a new license. Instead, it will just follow the terms and conditions of its license, but of course, it must be subjected to the general provisions of the revised Corporation Code and other special laws that is concerned. Section 142 provides the requirements for application of license of a foreign corporation. The requirements include first the articles of incorporation, and next is the bylaws, which must be certified in accordance to the law and must be translated to Philippines official language if necessary. Other requirements that must be provided if ever it is not yet stated in the articles of incorporation includes date and time of incorporation, address of principal office of corporation or the state of incorporation, the name and address of resident agents, place in the Philippines where it is intended to operate, specific purposes, name and address of present directors and officers, statement of authorized capital stock and aggregate number of shares, corporation's statement of outstanding capital stock and aggregate number of shares issued, and the statement of amount actually paid in, and other necessary information. The next paragraph of Section 142 requires a certificate under oath of the official in its home country that it allows Filipinos to do business with them and it is in good standing. This certificate must be translated in English, while the third paragraph requires a sworn statement from its president or an authorized person providing that the company is financially stable. The last paragraph is for foreign banking, financial, and insurance companies. They must follow all relevant laws in the Philippines that apply to them, in addition to any other requirements, while other types of foreign companies cannot apply for a license to operate here in the Philippines unless they first get permission from the proper government agency if the law requires it.
Section 143, the issuance of a license. Section 143 outlines the process for the issuance of a license to foreign corporation wishing to conduct business in the Philippines. Once the commissions confirm that the applicant has met all the legal requirements, it issues a license, allowing the corporation to do business as long as it remains compliant with its country of incorporation's law. Upon receipt of the license, the foreign corporation must deposit securities with the Commission within 60 days. These securities, valued at a minimum of 500,000, can include government bonds, share from registered company, or other instrument deemed suitable by the Commission. Additionally, the corporation must deposit an amount equivalent to 2% of its gross income, exceeding 10 million for the fiscal year if applicable. If the value of this deposit decreases by 10% or more, the corporation must provide additional securities. Conversely, if gross income declines or the value of the deposited securities increases significantly, the Commission may allow a reduction in the deposit. It decides to cease the operation, it can reclaim its deposit after proving it has no outstanding debts to the Philippine residents or the government. The rules for computing the securities deposit are determined by the Commission.
Section 144. Who may be a resident agent? A resident agent can either be an individual living in the Philippines or a domestic corporation legally operating in the country. The individual must have good moral character and a stable financial status. If a domestic corporation acts as a resident agent, it must have a solid financial standing and provide proof of good standing as certified to the SEC. Appointing a resident agent is for the purpose of receiving on behalf of the foreign corporation notice affecting the corporation pending the establishment of its local office, and summons and other legal processes and all proceedings for or against the corporation. Section 145. Resident Agent Service of Process. A foreign corporation requires to be licensed in order to operate in the Philippines. It must appoint a resident agent who resides in the Philippines. This agent is authorized to receive legal documents, which will be considered valid as if served to the corporation's officers at its main office. The foreign corporation must also agree that if it stops doing business in the Philippines or lacks a resident agent, legal documents can be served to the SEC instead, with the same legal validity. The SEC will then send a copy to the corporation's main office within 10 days. Any costs, for this service must be covered in advance by the requesting party. The resident agent must also notify the SEC of any address changes.
Section 146 is all about the laws applicable to a foreign corporation. And the general rule is that a foreign corporation is bound to follow the laws applicable to a domestic corporation. But the exceptions are the creation of the foreign corporation and the relations and duties of its stockholders, members, or directors. Those exceptions are not bound to follow the laws applicable to a domestic corporation, but all the other things and transactions of a foreign corporation is required to follow the laws of the domestic corporation.
Section 147, Amendments to Articles of Incorporations or Bylaws of Foreign Corporations. This section pertains to foreign corporations operating within the country. It states that if a foreign corporation already authorized to do business in the Philippines changes its articles of incorporations or bylaws, it must notify the Securities and Exchange Commissions within 60 days. This notification involves submitting certified copy of the amended documents, clearly highlighting the changes made. The filing of these amendments does not automatically expand or change the original scope of business activities which are permitted for the corporation in the Philippines, because any expansion to the scope of business operations would require separate approval from the SEC.
Section 148, Amendment License. Section 148 states that a foreign corporation that is allowed to do business in the Philippines must get an amendment license if it wants to change its corporate name or if it wants to start a new activities or expands its business in the country. To do this, the companies need to apply to the Commission, which is the authorities that oversees business licenses. Additionally, they must have support from the appropriate government agency when required. In other words, if a foreign company wants to change its name or add new business activities in the Philippines, it has to update its license accordingly.
Section 149, Merger or consolidation involving a foreign corporation licensed in the Philippines. Foreign corporations licensed in the Philippines can merge or consolidate with domestic corporations if allowed by both Philippine law and the foreign corporation's home country laws. They must follow the requirements for mergers or consolidations in the Philippines. If a licensed foreign corporation is involved in a merger or consolidation in its home country, it must submit the authenticated merger or consolidation documents to the SEC within 60 days. If the foreign corporation is absorbed in the merger, it must also apply to withdraw its Philippine license.
Section 150, Doing a Business Without a License. Section 150 prohibits unlicensed foreign corporations from participating in any legal proceedings within the country. This restriction applies to both court actions and administrative agency matters. So, to obtain a business license, a foreign corporation must first satisfy all the legal requirements, including those set by the Securities and Exchange Commission. The license allows the corporations to operate in the Philippines, provided that it maintains its corporate standing under its home country laws. And in order to consider that the corporation is doing a business and transactions, it requires ongoing business activities within the Philippines conducted in the corporation's own name and for its own benefits. Simply exporting goods to the Philippines doesn't qualify. However, lack of a license doesn't automatically prevent a foreign corporation from being sued. The license is only required if the corporation is actively conducting business within the country. So, there is an exemption to this rule, and that is based on the doctrine of Estoppel.
Section 151, Revocation of License. Section 151, this is the grounds for revoking or suspending a foreign corporation's license to operate in the Philippines. Non-compliance can lead to revocation, including failure to file annual reports, pay required fees or taxes, appoint or maintain a resident agent, notify the Commission of changes, or submit timely amendments to corporate documents. Licenses may also be revoked for misconduct such as submitting false false or misleading information or for unauthorized activities, including operating beyond approved business purposes or acting as an agent for unlicensed foreign corporations. Other grounds include engaging in activities that render the corporation unfit to conduct business in the Philippines. This provision ensures foreign corporations comply with the Philippine laws, operate transparently, and adhere to their authorized scope of operation. By enforcing accountability, it protects the country's economic and legal interests while maintaining the integrity of its business environment.
Section 152, the issuance of certificate of revocation. Section 152 explains that when a foreign corporation's license to do business in the Philippines is revoked, the Commission will issue a certificate of revocation. This means they are officially document that the company can no longer operate in the country. They will also send a copy of this certificate to the government agency when needed. Additionally, the Commission will mail a notice along with the certificate to the corporation at its registered office in the Philippines, and the company is to inform about the revocation. In simple words, if a company loses its business license, the authority will formally notify the company and other relevant agency about this change.
Section 153, withdrawal of a foreign corporation. A licensed foreign corporation may file a petition for withdrawal if it decided to withdraw in the Philippines. A certificate for withdrawal shall only be issued if the foreign corporation met all the requirements, such as all claims which have occurred in the Philippines have been settled, compromised, or paid. All taxes, imposts, assessments, and penalties lawfully due to the Philippine government or any of its agencies or political subdivisions have been paid. And lastly, a petition for withdrawal of license have been published once a week for 3 consecutive weeks in a newspaper of general circulation of the Philippines.